We just filed our amicus brief in the Supreme Court case United States v. Hemani. This case sits at the intersection of firearm ownership and marijuana possession, something that affects many gun owners in the 40 states where medical marijuana is legal and in 24 states where it's recreationally legal. Today, I'm going to summarize the case, dive into our brief, and explain how this case could affect your Second Amendment rights. I'm Phil, and you're watching Law and Ammo. Did you know that GOA is one of the most effective amicus brief filers nationwide? It's true. In fact, in a review of amici victories in policy-shifting cases, Gun Owners of America is listed as one of the most effective groups in the United States. These friend of the court briefs help give additional context to judges in cases and can even swing decisions. And it's thanks to the support of GOA members that we can be this effective. If you aren't already, consider becoming a member by heading over to gunowners.org and joining up so that we can continue fighting to restore the Second Amendment. Now back to the video. The Supreme Court will soon hear oral arguments in United States v. Hemani, a case about 18 U.S.C. 922 G3. Translated from legalese, that's the specific provision in U.S. Code that prohibits the possession of firearms by a person who is an unlawful user of or addicted to any controlled substance. The question at hand for SCOTUS is whether this law violates the Second Amendment. But there's a little bit more to this particular case than what meets the eye. Specifically, this case was selected and brought to the High Court by the federal government because of the plaintiff, Ali Hemani, and his unique background. Hemani was charged with violating 922 G3 when the FBI raided his house, finding him in possession of a Glock 19 and marijuana. The single-count indictment alleges that Hemani possessed a handgun as an unlawful user of marijuana. But in addition to his drug use and gun possession, Hemani had been the subject of a previous FBI investigation into his and his family's ties to the IRGC, the Iranian Revolutionary Guard Corps, a designated foreign terrorist organization.
Hemani's alleged ties run deep, even going as far as to say in a police interview that if Hemani was aware of an impending terrorist attack on U.S. soil by a, quote, Shia brother, he would not inform law enforcement.
If you'd like to know more about the specific details of the indictment and facts of the case, we've covered it in depth. I'll link that video in the description. So we're looking at quite the plaintiff, a borderline terrorist, to bring to the court to argue the constitutionality of possessing firearms and controlled substances. But that's by design. In fact, we've seen this exact same situation before. Viewers of the channel may be familiar with another case with a similar plaintiff, United States v. Raheem. Raheem involved the challenge in the Fifth Circuit to the prohibition of firearm possession by those under a domestic violence restraining order. Raheem, the defendant, had 4 state-level felonies already, but the Biden administration handpicked this case to challenge the then recent Bruen decision. That's because Raheem was a blatant abuser of his girlfriend, and in the days prior to his arrest had developed a habit of taking pot shots at random strangers. In other words, the worst possible set of facts. According to the Bruen decision, firearms regulations need to be justified through text, history, and tradition. If a law or regulation does not have a historical analog dating back to the founding of how the founders understood the Second Amendment, that law or regulation is unconstitutional. The Biden administration didn't like that, and they found their perfect challenge in the case of Zakai Rahimi. It's also important to note that while we filed an amicus brief in support of Rahimi, we weren't fighting for his freedom. Had his charges been dropped, he would still have 4 other felonies to answer for in Texas. In Rahimi, the Fifth Circuit found that the ban on possession of firearms by those under a domestic violence restraining order was unconstitutional under Bruen, and the Biden administration jumped on the opportunity to narrow the wide-reaching Bruen decision. Additionally, domestic violence restraining orders disarm both parties who the order applies to. So while the idea might be to protect a vulnerable individual from an aggressive domestic partner, in reality, these orders often prevent victims of domestic violence from being able to defend themselves. Raheem was an irredeemable character, and the Biden Justice Department bet on the facts of the case being so bad that the Supreme Court would have to rule in their favor. Did they get what they wanted? Well, kind of. The Biden Justice Department attempted to get the court to rule against the Bruen decision, going so far as to ask the court to disarm Raheem based on a standard of responsibility. Unfortunately, SCOTUS ruled against the Second Amendment, and the Biden admin strategy was vindicated, sort of. Thankfully, Biden's DOJ didn't get everything it wanted from the court's narrow ruling. Specifically, the court rejected the Biden DOJ standard of disarming Americans who weren't considered responsible, writing, "Finally, the court rejects the government's contention that Raheem may be disarmed simply because he's not responsible." The court used this term in Heller and Bruen to describe the class of citizens who undoubtedly enjoy the Second Amendment right. Those decisions, however, did not define the term and said nothing about the status of citizens who were not responsible. Even with this, the court's decision stands as bad Second Amendment case law, and now we have a similar situation at hand with the Hemani case. Ali Hemani is suspected to have connections to foreign terror organizations, was sympathetic to this country's enemies, and was in the possession of drugs and a gun at the time of his arrest. The facts of the case don't paint a pretty picture, and the Supreme Court will need to separate those facts to get to the heart of the matter, 922G3. That's why we at Gun Owners of America recently submitted an amicus brief in support of Hemani. In our brief, we make four major arguments against the statute and the federal government. First, the federal government has built their argument on the shakiest of historical foundations. According to the government, because Congress passed 922G3 into law, dangerous categories of people can be disarmed, and the law itself passes constitutional scrutiny. But the historical laws that the government cites in support of this broad, categorical disarmament are narrow and irregular. Those laws were colonial enactments that disarmed British loyalists during the Revolutionary War. But being temporary wartime measures during the Revolution, they didn't even survive the birth of the United States. Why is it that the US government is citing the disarmament of enemy loyalists during the Revolutionary War as a historical analog for gun owners who smoke marijuana in the present day? Second, the government attempts to tie its disarmament theory to the regulation of founding-era drunkards, which took the form of vagrancy, civil commitment, and surety laws. The fact of the matter here is that while the government cites these laws as regulations of drunkards in the founding era, none of these laws were firearm regulations or gun laws whatsoever. In fact, we argue that these laws are completely irrelevant under the court's precedents and can't be used as analogs to support 922G3. Third, the government fails to consider the complete historical record and the litany of examples that form a contrary tradition, one in which the founding generation accommodated alcohol and drug use together with firearm possession free of criminal penalty. Historical evidence shows that it was the widespread tradition of founding-era militias to use alcohol and other substances.
Militia musters often couldn't proceed because the participants fell down drunk. For instance, one pastor recounted meeting people coming from a militia muster, drunk and staggering along the lands and paths, in 1802. Similarly, in 1840, the militia of Racine County, Wisconsin, was reported to have gallantly trained till noon, and when they adjourned to the Fulton House for dinner, they all got so drunk that they couldn't muster at all the rest of the day.
Even with respect to drugs, several early American figures possessed firearms while using such substances. Thomas Jefferson was a fierce advocate of the right to keep and bear arms, even going so far as to say that the use of firearms was essential to a healthy lifestyle.
Even so, historical evidence suggests that Jefferson was also addicted to laudanum, an opium-based drug.
And perhaps most notably, some historical records suggest that Abraham Lincoln treated his depression, then known as melancholy, using mercury-based medicines. Despite this, Lincoln participated in a live-fire demonstration of a 7-shot repeating rifle near the unfinished Washington Monument in 1863. There is no evidence that Americans during these periods would have permitted a law that disarmed a person who occasionally used marijuana and unrelatedly kept a firearm in a closet at home. Finally, and maybe most important, our amicus brief calls out the government for its pattern of choosing plaintiffs with particularly bad backgrounds. This is a quote from our brief. The government cannot continue its pattern of handpicking unsympathetic criminal defendants to justify its preferred gun control. The framers understood that our Constitution was made only for a moral and religious people. It is wholly inadequate for the government of any other. The government's use of problematic defendants to broadly undermine the rights of tens of millions of Americans defies the plan of the framers. This court should decide the easy question presented and ignore the government's irrelevant character assassination of the respondent here. This is particularly relevant given that the Biden Department of Justice attempted to narrow the Bruen decision in a similar fashion with the Raheem case. SCOTUS cannot allow the DOJ to continue to undermine Second Amendment rights by handpicking the worst plaintiffs that they can find. We'll be keeping an eye for when U.S. v. Hemani heads for oral arguments before the Supreme Court, and as always, we'll keep you updated on this case as it moves forward. Thanks for watching.